All right, we're back. This is video 3 of criminal process, and last time we were taking a look at Beccaria, and we were looking at both sides of this nature versus nurture approach to crime. All right, so we're going to get to a few specific cases now. So thank you for your patience. I believe I asked you to read about Iowa versus Felter. Not a famous case, but a case that gives us, again, a kind of a glimpse into 19th century views on this and how things maybe are similar and how they've changed. But in this particular case, I'm going to focus on something that has really helped us to fashion a view of crime and justice, and that is the idea of culpability. Remember, we talked a little bit about this a few weeks ago. So in this particular case, we won't go through all the specifics. I'm assuming you read it. There was this issue of, was the person who committed this crime not were they did they do it or not? It's, were they responsible for doing it or not? In other words, the facts of the case were not in question that this person actually committed this crime, but is someone who committed a crime always responsible for that crime? Are they always, and what does that say about our view of a human being and what a crime is? So there's this interesting defense that was provided. It was called the irresistible impulse. Sometimes it's in some 19th century legal language, it's called the wild beast defense. It's been updated in the 20th century and 21st century, but it's the same basic idea that if someone is not in their right mind while they're committing that crime, are they as responsible for committing that crime and therefore as susceptible to punishment as someone who is behaving differently or thinking differently at the time? So the criterion in court is the difference between, do they know the difference between right and wrong at the time of the crime? That shows responsibility and choice, right? You see what that presumes. It presumes that you know logically the difference between two different things. So those who recognize the difference may in fact go to prison or be executed. Justice Dillon's minority opinion is really interesting. It's that either this is a crime of passion or insanity. So the word insane is not a clinical term. You might find that surprising to learn, but it's actually a legal term. Like criminally insane is a legal term, not so much a psychological one. But what's interesting here is what's the difference between a crime of profit and a crime of passion? And we see this kind of mixed view of crimes. Even now, we might be conflicted about some of the nature of these crimes, that you might commit a crime in the heat of the moment, where some wild beast takes over, as opposed to plotting out coldly and rationally. And that could also show psychosis or psychological problems if you are planning out a horrific crime and execute it and don't seem to show any remorse for that. By the way, this late 19th century is the same time that the short story Dr. Jekyll and Mr. Hyde was written, in which a wild beast comes out. It's the same person, but really was getting at the same kind of question, which a lot of people were struggling with. Again, the presumption here is a strongly embedded Enlightenment idea. I can't stress this enough. We still have this, that a human being is defined by rationality. So if you're irrational, then you are held to different standards, or you're not fully human, you're not in your right mind, you're not capable of certain things. And this, just to mix this up a little bit, was also the time in which the term hysteria emerged from the legal and psychological realms to describe women that at certain, shall we say, periods throughout a month might seem quote-unquote irrational, and therefore they would be more likely to commit crimes, or they might not be able to understand law or politics, and this might help to explain a sort of a deeply held patriarchal view that women are, inferior when it comes to rational capabilities. But also people are autonomous. They have control over their actions. Autonomy means sort of control over your own will. So these are presumptions that are on display in these controversies that we're still struggling with in some ways. Causation. So at the root of this is the concept of competency. So not just culpability, is someone responsible or guilty for something, but also are they competent for their own actions? Do they have control over their behavior? So how is mental ability related to responsibility? The answer is it's complicated. So what are the criteria for responsibility in a post-enlightenment civilization? Another good question that we could ponder for a long time. The standard that is still in jurisprudence, and if you go on to law school, you might actually encounter this case or references to this case. This is called the McNaughton case in 1843, in which the legal principle sort of emerged that a defendant, in this particular case, the defendant was not aware of the nature or quality of their action or of the difference between right and wrong at the time of the crime, and that becomes the gold standard for understanding the relationship between competency and culpability. So if they're not mentally capable of understanding that at the time of the crime, that's still kind of a basic standard for how to treat them in the legal process when crimes are committed. So again, we're not talking about whether or not the crime actually is committed. It's when everyone agrees on that, and the question is how to approach that legally. So, for example, a case within our lifetimes is Atkins versus Virginia, in which the court held that you can't execute those with mental disabilities. There are a whole bunch, as you might expect, a whole bunch of nuances to that, and we're going to talk about a couple of those. Another thing that might give us a glimpse into this idea of eugenics coming back to haunt us again is that as late as 1927, in the Buck versus Bell case, a state could forcibly sterilize intellectually disabled. That's no longer a leading case, as you might not find that surprising, but even just 90 years ago or so, that was standard. Again, the thinking was a social Darwinist eugenics one, that people who are mentally inferior should be weeded out. But that was legal in some situations up until the late 20s, early 1930s. So here's a pop quiz. I'm going to pause on some of these so you can think about it, but you can also hit pause after I mention these, just to think them over. So here's the first question. Does the Constitution guarantee stun guns for self-defense? Is that something that is, if we're taking a look at crimes, or preventing crimes, and things like that, does the Second Amendment allow you to protect yourself? Well, yes, but does it allow you to protect yourself to the extent that you should be allowed to have a stun gun to protect yourself? So think about that. Does the Constitution guarantee that or not? Well, according to the latest case on that, no, it does not guarantee that, and there's more to that. You can look that up on Saitano versus Massachusetts a few years ago. Here's another question, and again, you can pause after this to kind of think it over. Can a defendant confront a 3-year-old in court for a statement made out of court against that defendant? So, we've got all sorts of things here about competency, right? What a 3-year-old should and can say that could be taken as evidence in a criminal investigation and a jury trial, criminal trial. So can a defendant do that? Can they confront them and ask them questions, or have their lawyer ask them questions, even if that was made out of court? If you understand what's at stake there. Well, the answer is no. At least in that situation, Ohio versus Clark in 2015, the court said no. That's actually for the protection of the innocent there in that respect. So it's helpful to know that. Here's another question: is the imposition of the death penalty for the rape of a child cruel and unusual punishment? And this has popped up from time to time, as people might, it's understandable with such a terrible crime that people might feel like the death penalty may or may not be justified in that you, for various maybe emotional or legal reasons, philosophical reasons, feel that should or should not be imposed. In this particular case, the answer is yes. the imposition of the death penalty for rape, not murder, not a capital crime, is considered cruel and unusual. And we'll take a look at the general principle of that later on when we take a look at proportionality. So this is a fairly recent case as well. I believe this is the last one for the slide, is a retroactive internet registry for sex offenders, an ex post facto, that is unconstitutional. The Constitution prevents ex post facto laws. Is that an ex post facto punishment? In other words, for sex offenders who have gone through the criminal process and have been released, having done their time, and some sort of public registry made available with their information on that for sex offenders, is that unconstitutional? And you might ask a question, is it level 1, 2, or 3? And in this particular case, the court said no. A registry like that serves a public good, and it's not a punishment that goes against the Constitution. So interesting to think about. Excuse me. And so we're going to take a look at some the process. We've been looking at sort of causes and history and things like that. We're going to take a look at a few little glimpses into the process and some of the controversies that have happened in the America's history of this. So again, these are just kind of highlights of a few things related to the process. So the process of a crime being committed and then all the way to punishment, which we will get to later. So Screws versus U.S. Provides an interesting little insight here. Again, if we had more time, I would go into more of the detail about each one of these cases. They're all fascinating. But in this particular case, someone was there's a crime committed. The arresting officers, I think, if I remember correctly, in Screws versus U.S. in 1945, the suspect was taken into the back of a police car and was beaten. And any number of things can happen. And if you study this for your profession, you will know that every single action you take when apprehending a suspect is important. The manner in which you run someone down, the struggle of what someone says or is perceived to have said, I can't breathe, what are the circumstances? Those are all very important. This is like a few generations before many of those considerations. And so having someone roughed up, quote unquote, or maybe even killed as they were resisting arrest was not as uncommon as you might expect back then. So this eventually went to the Supreme Court, and it's kind of was a game changer. It said that arresting officers are responsible for providing some sort of fair arrest to protect them, not to the detriment of other people, but they have to be treated as innocent before they're convicted, right? I think there are three cases on this slide, and Gideon versus Wainwright. If any of you are doing the alternate quiz, the video that I'm asking you to do is on this Gideon versus Wainwright, and in this case, an indigent defendant, a defendant who's facing a trial, has a right to a legal counsel even if they don't have the money, and even in a non-capital case. And that's what was so significant about Gideon versus Wainwright. It's that we knew that was the case in capital cases, but even in misdemeanors or smaller crimes, that's the case as well. So even if you're poor, the court must provide. If you're declared poor, the court must provide legal defense for you. And Miranda versus Arizona, very famously in 1966, sort of reified the exclusionary rule, which we've already looked at. So statements obtained in custodial police interrogation are not necessarily admissible. There are some exceptions to that. We're going to talk about some more things in that fourth and probably final video right after this. So look for that. Thanks, everyone. We'll see you at that next video.